This is our last case of the morning session. It is Meyers versus, you'll correct me, Rieck and Shelby Nursing Center. It is a 15-minute mini oral argument on the application. Mr. McGranzotto, you may attempt to reserve time and you may proceed if you're ready.
Thank you. Good morning, Mark McGranzotto on behalf of the plaintiff appellant. In its June order calling for this hearing, the court identified two issues that it wanted the parties to address, both of which deal with a standing order. The significance of that standing order was on the night that Mr. Corrado died, it was complied with in one respect, allowing the nurse who was attending to Mr. Corrado to prescribe a drug which he would not have been authorized to otherwise prescribe. But it was not adhered to, and in one other respect. And it's that claim that the plaintiff added to the case by amendment. And the first question that the court has raised is whether that claim does in fact state a claim for ordinary negligence or medical malpractice. And the essence of the medical malpractice claim, as the court has obviously identified in Doris and Bryant and Wilson before that, is whether there is in fact medical judgment involved in the decision-making of the person. This standing order is in essence the opposite of medical judgment. It is in fact an order of the doctor which takes away any decision-making from the person who is subject to the order and instead directs that person to follow it. The nurse in question, Mr. Gerby, confirmed that that was in fact the effect of the standing order. He was in fact required to administer the drug that he administered. He was in fact required to contact a physician immediately after two times that Mr. Corrado vomited. The Court of Appeals got this issue seriously wrong when it decided that this, in fact, rested only in the area of malpractice. It cited basically two reasons, both of which were not very accurate. The first one that they claimed was that a layperson wouldn't understand that you have to call a doctor after two periods of or two instances of vomiting. That is not the claim being made in this case. The claim being made in the case is that Mr. Gerby was compelled to comply with the standing order, not that he was required to, by the standard of care, if you will, to contact a physician. The second thing that the Court of Appeals seriously got wrong about this case is they abandoned the test of Bryant and Doris, that is medical judgment, and instead suggested that the particular holding of the case in Bryant was somehow binding on the parties. If you recall, Bryant had four specific issues that the plaintiff had raised, and this court decided that one of those, which had to do with failing to take corrective action, was in fact a claim of ordinary negligence, not medical malpractice. Obviously, the issue in the specific issue in Bryant was whether that particular claim was in fact ordinary negligence or med mal. But the Court of Appeals, unfortunately, in this case, seemed to elevate the specific holding of Bryant and completely abandon the actual test of medical judgment. So in that sense, the first issue that the Court of Appeals decided in this case, and on which the court has asked for argument, was decided incorrectly.
Why don't I interrupt you? And I know you probably have something to say about the second issue, but let's see what happens. Justice Cavanagh.
I don't have any questions right now.
Justice Welch.
I actually have, Mr. McGranzotto, just a procedural question that admittedly is a little bit confusing in this case. There was a motion to amend the complaint, I know, filed, so you know where I'm going. So
yes,
filed in the trial court. There was also a motion for summary disposition filed. And that motion for summary disposition was granted, even though the motion to amend, I believe, was still pending, and addressed matters or that were in, I believe, the motion to amend. So I'm trying to figure out, did the trial court get that wrong in the order of how they address things?
Yeah, so it's a procedural glitch in the case. The fact is that the plaintiff moved to amend. The trial judge, Judge Massaroni, decided that the plaintiff could amend to state this ordinary negligence claim. But before the amended complaint could be filed, the defendant filed a motion for summary disposition. So we actually have, and then regrettably, in my estimation, the Court of Appeals decided to review this case at a time when there was no amended complaint. They granted leave. So technically, there is no amended complaint that was filed in this case. So when we're talking about the theories, the claims being made in the case, we're talking about a complaint that has yet to be filed. Strange.
Okay. Okay, so I think I understand what happened then. My next question is, then I'll just get into the substantive issue. This issue of, whether compliance with a standing order, whether it sounds an ordinary negligence or med mal, it appears we need an expert to sort of explain how standing orders work. How do we get around that not being med mal if we need an expert to explain that?
All that I care about, in my estimation, to make this into an ordinary negligence case is that this was, in fact, compelled behavior. And that was testified to by Mr. Gerby, the nurse in question. It was testified to by the plaintiff's expert, and perhaps more importantly, the defendant's expert, Ms. Hildebrandt, also testified that standing orders are required. Now, I will admit that the defendant's administrative staff was able to testify that, no, it's just a recommendation. But there clearly is a question of fact that exists in this case, and the defendant's own expert so testified that this is mandatory. There is no discretion. It must be followed.
Okay, just following back up on my first question, if we were to agree with the Court of Appeals that the motion to amend should have been denied because the claims were rooted in malpractice, would the current arguments be moot? I'm trying to figure out procedurally what our options are.
Obviously, if the motion to amend were denied, we wouldn't have the ordinary negligence claim because it's not in the complaint as it exists at the present time.
It should have been denied, I should say. Yes.
Yeah, it shouldn't be denied. That's the point. And the trial judge, as you know, did not deny it. He granted it, obviously.
Justice Welch, do you have additional questions?
No, I don't. Thank you. I'm all set.
Justice Zahra?
No questions at this time. Thank you.
Justice Viviano?
No questions.
Justice Bernstein?
Let me spend the second part here on the second issue that the court
Actually,
has asked for.
I'm
sorry.
Justice Bernstein is not participating in this case. That's why I was like, did he leave? What's happening? Justice Clement?
No questions.
Okay, now go to your second issue.
Okay, I'm sorry. The second issue also involves a decision made by the trial court. It basically, once we were left with only a malpractice case, the Court of Appeals ruled in this case that the standing orders are inadmissible for any purpose. The legal justification for this rests in a 1988 decision of the Court of Appeals, the Gallagher case, that has generated a lot of controversy, in my opinion. But the Gallagher case basically holds that a policies and procedures of a hospital or any medical provider are not admissible at all in a medical malpractice case. As I've first indicated, the holding in Gallagher is not applicable here for the simple reason that we talked about before, and that is this is not a policy or procedure. This is an order. It's an order of a doctor. Okay, these are standing orders that are developed by the staff, the physicians at Shelby, and they are orders. I mean, it would be ludicrous to suggest that in a medical malpractice case where a nurse fails to give a drug that a doctor has ordered at the bedside, that doctor's order is somehow inadmissible when the failure to give the medicine results in some adverse consequences and a medical malpractice case results.
Mr. McGranzotto, can I ask you, if say we disagree with you that the claim states an ordinary negligence claim, that it's one of medical malpractice.
Yes.
On this issue of the standing order, and say we agree that you know it's not a complete bar, that the order or policies aren't admissible. You know, there may be circumstances where they are relevant, and you know the trial court should determine that. Is the standing order in this case relevant to a remaining medical malpractice claim that you have?
Yes, absolutely. I mean, that's what the Court of Appeals has left us with. I mean, that was the order of their decision making. They said you've only got a medical malpractice case left, but now in that medical malpractice case, you can't even introduce this standing order. That's how the Court of Appeals ruled in this case. So yes.
Okay, so the admissibility of the order isn't depending on us agreeing with the first issue, agreeing with you on the first issue.
These basically were independent determinations by the Court of Appeals. They're not.
Okay, thank you. Okay.
So the getting back to the Gallagher issue, there are a number of issues. This court has never decided a case that presents Gallagher. I think this is an appropriate case for doing so. It's a very significant question of what effect policies and procedures, internal policies and procedures have in a personal injury case that arises from the failure to follow those. The Gallagher decision is predicated on the standard of care, that the policies and procedures can't establish standard of care. But the initial question presented, besides the question of whether policies and procedures would apply to a standing order, is whether the ruling in the Gallagher case would apply to a situation in which the plaintiff is not claiming that this is in fact an element of the standard of care. Because what's important here is that the standard of care is not that Mr. Gerby was supposed to call a doctor. The standard of care would be testimony by plaintiff's expert that a nurse dealing with this standing order must comply with the standing order. That's the standard of care. Gallagher says you can't introduce these policies and procedures to establish standard of care. It would not be introduced in this situation to establish standard of care. That's
Mr. McCormack, can I jump in again? Sorry. Is the problem your problem really with Gallagher? I don't read Gallagher as saying a per se rule. I mean, they say, you know, that there are circumstances in which even internal rules and regulations would be admissible, right, in the right case. And obviously that's a determination by the judge. So the problem maybe is not necessarily with Gallagher, but with, and I'm probably saying it wrong, Gillick, with the order in Gillick that reversed for the reasons of the dissent, although the dissent, I'm not sure that our order in Gillick really rejects the majority. Because the dissent in Gillick had two bases for why they would have dissented. Mm-hmm. So it's not necessarily that clear that we agree with that Gallagher is a hard and fast rule. Is that right?
Yep. It's pronounced, by the way, Gillick. It was my client. Okay. But you should know that I raised similar arguments in the Gillick case. As to the application of Gallagher, including the Wackneen issue and the question of whether the rules of evidence actually displaced common law policy-related exclusionary rules with respect to evidence presented at trial. Interestingly enough, I argued Gillick and Wackney to several justices who were on the Supreme Court in Wackney. I thought I had a leg up in terms of getting them to accept the fact. I was also presenting the Woodman concurring opinion by Justice Markman on the same point to Justice Markman. What happened in the Gillick case was kind of surprising to me. I'll just finish this quickly. Because the court didn't tell me I was wrong with respect to my argument regarding the relationship between common law rules of negligence of evidence and the Michigan rules regarding evidence. They did what they did instead is they heard argument in the case. They then didn't address the Wackney issue that I had raised. Instead, they adopted a subpar, I can call it that, dissent from the Court of Appeals. And the Wackney issue and the impact of the Michigan rules of evidence, the adoption of them, was never addressed by the court in Gillick, unfortunately.
Okay, thank you.
Thank you, Mr. Granzotto. Ms. Kennedy.
Good afternoon, Your Honors. Alyssa Kennedy, Abbott Nicholson, appearing on behalf of Shelby Nursing Center Joint Venture. Your Honors, essentially in an overview of the Court of Appeals decision, we see no reason to disturb the panel's decision below, that it's consistent with the published and the unpublished decisions that are cited within it, specifically Bryant and the Cox v. Board of Hospital Managers, which outlines the standard of care for a nurse, as well as Gallagher versus Detroit. These are time-tested common law tests that this court has applied, and the Court of Appeals applied after a detailed review of the factual circumstances in this case. Specifically with regards to then the ordinary negligence versus medical malpractice. With regards to the procedural glitch, what really occurred is we had a pending motion for all ordinary negligence claims to be removed. Prior to that being determined, they filed a motion to amend to add additional claims related to the standing order once the standing order was handed over. We then filed a motion against that and essentially a supplemental motion for summary disposition for those claims to get them before the trial court. At this time, the motion with regards to all of the ordinary negligence claims was not determined. However, there's a motion to amend the complaint, which essentially outlines exactly what the complaint would look like and the claims would be with regards to ordinary negligence. And really that's what the Court of Appeals determined when it determined it could rule on what that claim would be. And essentially the claim is really, Justice Viviano stated in trial that it would be astounding if a trial was held to determine the nature of the claims pled in the complaint. The estate agrees that the binding effect of the standing order is an issue of fact that hasn't been resolved in this case. So to insert into its pleading that it's a mandatory order or required for this nurse to follow essentially is an issue of fact that requires expert testimony as to what the standing order really entailed. The medical professionals disagree. And the Court of Appeals addressed this by stating that the distinction on the mandatory nature of the standing order by the parties was essentially misplaced. The Court of Appeals said that the standard or the rule is that it's beyond dispute that the order isn't applicable outside the confines of the defendant nursing home. That expert testimony needs to be determined to determine the local community standard of care. And the very fact that information outside the realm of common knowledge, i.e. the standing order itself, is necessary to determine liability supports the conclusion for medical malpractice as opposed to ordinary negligence. So essentially, there's no new argument that's being made by the estate in regards to the pleading or what's intended to be pled in this matter. And moving on to Bryant, the Court of Appeals essentially applied the test to the facts of the case. The Bryant court essentially indicated that no expert testimony was necessary to determine that some sort of corrective action should have been taken. There are no factual similarities here. They also indicated in Bryant that a failure to protect theory was the only theory. And that was, again, a doing nothing, essentially. That's not the case here. There's no doubt that Mr. Gerby did something in this case. The question is whether he adequately did something, whether he adequately followed the standing order. And that places it once again under the Bryant test into medical malpractice. In going into...
let me interrupt you now and just see what the questions are, and then we can get back, okay? And I'll start with Justice Cavanagh.
I'm going to jump to the second issue on the admissibility of the order. And I think in your opening, you suggested that the Court of Appeals opinion, I think in this regard, was consistent with Gallagher. But doesn't Gallagher say that there are circumstances in which even internal rules and regulations, and I understand the argument that this order is different than just an internal rule or regulation, but even Gallagher recognizes that there are circumstances in which it may be admissible, particularly where there's a causal relationship between the violation of that rule and the injury.
Yes. I mean, I think that the Court of Appeals decision in this case doesn't necessarily close Gallagher. It applies Gallagher, essentially, in looking at the facts and stating how is this standing order being used in this case and what is its relevancy. And the determination is that it's being used to establish standard of care. No, I know that the estate states that that's not what it's being used for, but if it isn't, then they're trying to establish strict liability with compliance of the standing order. There's really no two ways.
Well, the plaintiff has an expert that testifies consistently with the standing order, right? So they're not relying solely on the standing order to establish the standard of care. They're saying it's relevant, it's evidence in support of their contention of what is the standard of care, supporting their expert. So it's not the sole evidence.
No, it is not the sole evidence. And they also can bring these claims with regards to whether or not he should have contacted the physician through their expert testimony. And that has been done and can be done. The issue is the standing order does not apply to nurses in the local community. And in Cox v. Board of Hospital Managers, we specifically laid out what the standard of care for nurses are. And it's the local community standard of care. And what the Court of Appeals determined was that this facility policy, whether it's mandatory and what it contains, only pertains to the nurses within this facility. And that's really what the crux of Gallagher and what came before with regards to simply companies in general, is that the policies don't apply outside of those four walls.
Except doesn't plaintiff's experts say that the standard in the community is in fact consistent with what the standing order is? So I get that maybe the standing order could be different, but in this case, the allegation is that, or they have an expert that says the standard of care is exactly what your client put in its standing order, and it wasn't followed.
In that way, the Court of Appeals specifically indicated that in its footnote of number 5, that the conclusion shouldn't be construed to suggest that they can't establish that the conduct that purportedly violated the standing order, this delay in contacting the physician, that they can't establish that through expert testimony, and they can't. The issue is the relevance of this document and being used to establish standard of care. It can be established through the expert testimony that is the standard of care, because that's the local community standard of care that the expert is testifying as to.
So can I ask just a final question of why is it that your client, if it is consistent with what their expert is testifying to, and you're saying that absolutely can come in through their expert, what is the problem with admitting the order as consistent with their expert testimony? Is it that you're concerned that that the jury or finder of fact or something may determine that even the defendant agrees with the plaintiff's expert because they put that in their own order?
And I think that really gets down to what Gallagher is about in terms of internal company policies being used to establish or even support the legal duty or the negligence, and why those are protected. They specifically state in, and I believe it is in Zadrowski v. Murphy, with regards to a Joint Commission of Hospitals Association, that they can't use the internal rules because they can't establish the legal duty. The policy in that case was for bus operators to wait until passengers are seated. That created a duty to assist the passenger to her seat. That can be testified as the duty by the expert. However, using the internal policies has the effect of, is really a public policy concern. It encourages all of these companies, including hospital facilities, retailers, et cetera. Why we have an amicus brief from the Michigan Manufacturers Association, I think, is relevant to this, that it encourages them to abandon policies enacted for the purpose of protecting others to avoid liability. And I think that that's critical in protecting these standing orders that may be above the standard of care, below the standard of care, at the standard of care. But what's important is they're not the standard of care defined by this court in Cox, which is a local community standard of care established by a nurse familiar with the local community standard of care.
Okay.
And
Thank
I think,
you.
Thank you.
Justice Welch?
I have no questions. Thank you.
Ms. Kennedy, I think Justice Cavanagh covered most of what I was curious about, but I hear your point that you're worried that what the plaintiff wants to use the standing order for is to show standard of care. But if it's inconsistent with the community standard of care, I could see, depending on which way it's inconsistent, it might hurt the plaintiff's case. It's not, so I'm not sure I understand why the standing order isn't relevant to some of the med mal claims that nobody disputes are properly in the case. For example, failure to timely and appropriately respond to the patient's needs, failure to hold the, whatever you call the feeding tube and notify medical staff in the presence of nausea and vomiting. Isn't the standing order relevant to those claims?
I think the standing order, while it could be relevant, and it could be the standard of care, that testimony is properly through the expert that's supplying that and not the rules and regulations. And that really gets down to, a hypothetical where a private physician established guidelines for his practice and something goes wrong and he is used, that those guidelines are used against him when the doctor up the street didn't have those same guidelines. And I think what it does is it positions, it really overrules the entire purpose of the community standard of care. And that's to establish that through the expert testimony. And it's important that these claims aren't denied to the plaintiff if they can be established from their expert testimony.
I feel like we're talking past each other. I think the plaintiff understands that it's going to need an expert to say what the standard of care is. And and if they don't, then, that'll be a problem probably. But the question is there ever, when would you think this standing order might have some relevance in a med mal case? Can you give me an example?
I think specifically for policies, when we're talking about policies that either are very specific in terms of what they have to do at a certain facility because of how a facility is laid out or managed, I think but that's not the case here. What it says is immediately notify a physician. And that is a policy across the board that really would open the door for any policy that a healthcare facility has to provide good care, that it can be used as supplemental evidence and important evidence, because I think it can't be understated the import of that to a jury to look at these policies and procedures on top of the expert testimony. I think that it's critical that you look at how that does really argue for strict liability. And while they say they aren't going to, I think we come up with issues that confuse a jury as to strict liability.
Okay, I feel like I've eaten up, or didn't mean to do that. Let me go to see who else has questions. Justice Zahra.
All right, Justice Cavanagh tried, you tried, let me try. The standing order is not itself the standard of care. I'll give you that. And it can't add to or otherwise alter the standard of care. But it seems to me that it nonetheless could constitute relevant evidence under MRE 401 for purposes of establishing what is the standard of care under Cox. where am I going wrong? And isn't this something ultimately that's left to the discretion of the trial court in admitting evidence under 401?
And I think that the Court of Appeals, if you read their opinion, addresses really compromising Gallagher with the Michigan rules of evidence, and that Gallagher was decided after the rules of evidence were instituted, and that the common rule in Gallagher essentially was made in light of the rules of evidence. And Gallagher was essentially the same type of policies of a hospital that they wanted to use to determine monitoring and whether or not the person was being monitored correctly. And that was determined afterwards. And I think in terms of the 401, that the crux is that it's an evidence that has a tendency to make the existence of any fact that is of consequence to the determination of an action more probable or less than it would be without. Well, the appropriate determination here is what is the local community standard of care, and was it adhered to by this nurse? And when you look at what the law defines as the standard of care and it being relevant to the law, that is where you come up with it isn't relevant in terms of how we define what the nursing standard of care is in Michigan. And that is very specifically laid out to be the local community standard of care. And in terms of looking at relevance to the standard of care, that's where the relevance determination kind of breaks down, and it isn't relevant to the actual issues in this case, along with the other problems that we have with it coming in and essentially being used as a form of strict liability because it is a policy and procedure. And those are the same issues that came up in other companies in the multiple cases, starting with McKernan back in, then Dixon, Gallagher followed through, is really that exact same concern. And to address the MRE and the rules of relevance and relevancy, Gallagher does that. And it's determined after the rules of evidence have been instituted. So really the controlling law in terms of that is looking at Gallagher and also then looking at what is the relevant determination in standard of care. And that is a local community standard of care. And is that standing order relevant to that standard of care? And that's where the Court of Appeals determined that, we don't have that relevancy as to this facility-specific policy.
But the local community standard of care, does it not also incorporate this facility's practice in making that determination? This facility doesn't define the local community standard of care, but isn't it something that ought to be considered?
Well, I don't think in this case it should be considered. And I do think that, like I said, Gallagher might not be a full cutoff on never having these policies implemented or used. However, in this case, when they're really trying to get it in terms of an immediate notification to a physician, I don't think that it really reaches to that. It doesn't really satisfy the local standard of care. I mean, and I think in terms of keeping them out, in the intent of the Michigan legislature and Cox in determining what the standard of care is to narrow the issues and not open up policy books where the defense and the plaintiff are using them as alleged evidence, essentially, of a local community standard of care, which is the only thing they can be used for in a medical malpractice case to be relevant, would be as to the standard of care. Which is a local community standard of care. And the reason that it's been, unfortunately in Gallagher and all of these other cases, there's good public policy reasons to protect these policies and procedures, because we encourage good policies and procedures that often go above and beyond the standard of care. In the community.
I get it. Thank you.
Thank you.
Justice Viviano.
No questions. Thank you.
Justice Clement.
No questions. Thank you.
Okay, we have used up way more of your time and yours as well, Mr. McGranzotto. The case will be submitted. Thank you both. That will conclude this morning's case call. We were going to come back at 12:30, but that doesn't give anybody nearly enough time to eat. So let's come back at 1 o'clock for our afternoon session. Hopefully, Larry, you can notify the attorneys from this afternoon's case call. Thank you both.
Thank you, Anna.